Hello there, welcome. This is the Disability Law Show you've tuned into. Welcome to it once again. John Scholes here, Sivan Tumarkin right there, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. Reaching out is simple and it's encouraged. 1-855-821-5900. Anytime you feel the need. You can email as well, help@disabilityrights.ca. And there's some other websites we'll get through throughout the half hour as well. I want you to be aware of. On the show today, the difference between a denial of LTD and cutoff of benefits and what you should do next. That is on the way shortly. But my friend, we always start off with a matter or a week that was, something you've been working on. What do you got?
Very interesting week, John. Lots of very interesting questions. And so I picked one that I thought was quite relevant because we always talk about appeals. And we always talk about how much I hate people appealing long-term disability denials.
Wasting their time.
Wasting their times, exactly. However, some people feel that, look, yes, Sivan and Martin and James and Tamar and all those good guys from Samfiru Tumarkin talk about how much they hate appeals. But you know what? It seems semi-legit when the insurance company tells me to appeal, and I really, really don't like speaking with lawyers, despite the fact that we're good guys, easygoing guys. I'm going to try and appeal anyways. Give it a shot. Exactly. And so I spoke this week with a lady, really interesting. She's in her early 40s. She's a dental hygienist. She has three kids, small kids at home, and she's off work. She's disabled, psychological issues. And she did exactly that. She was denied LTD, long-term disability, and she decided to appeal. Now, she's put in...
She was asked to appeal.
She was asked to appeal, exactly. She was denied the claim, and of course, when you get denied, you get a letter, formal letter that says, here's the reason why you don't qualify. And by the way, at the end, there's a paragraph or two that talks about you appealing if you want, and then they'll assess any new documentation you give them.
Gotcha.
And so she decides to appeal. And by the way, one of the reasons why people want to appeal as opposed to go the legal route is because they want to seem compliant.
Yeah.
That's the other thing, right? Insurance companies love it when you are compliant with them because then they have you under their thumb. Anyways, she decides to appeal. But she's very nervous about it. And she's already filed the appeal. She's waiting for a response now. Mm-hmm. And she's speaking with her brother, and her brother watches our show and listens to the radio shows. And he says, me too. And he says to her, he says, listen, why don't you speak with Sivan? Why don't you at least contact him? Yeah. Yes, you've appealed. Yes, he says not to appeal. But you know what? At least you'll know what to do if you get denied the appeal. I mean, why not have that information now, just in case? If you don't need it, if you get approved, fantastic. But maybe you do, in fact, need their help. And so she does what he says. She follows his advice, and she calls me.
Okay.
And she's very sheepish, right? And she's very kind of hesitant. And she thinks I'm going to be angry at her for calling me about advice to do with her LTD claim when she's already appealed. And it was far from that. I told her, look, I understand. Many people call me either before the appeal, during their appeal, or after they've appealed and gotten denied. I don't get angry. I simply want to help. When I tell you not to appeal or to at least call us before you appeal, I just want to save you time and aggravation and frustration. Because that's what happens with these appeals. It takes sometimes months for you to get a decision, and it's a negative decision, and you feel beat up. You feel like you've gotten 15 rounds with Rocky Balboa, right? And the insurance company's punching on you, and meanwhile, you are disabled. You have your own issues to deal with. So I'm not angry at all, absolutely not. And I'll tell anyone out there, if you are appealing a long-term disability denial, give us a call. Even if you haven't received yet the answer from the insurance company, it costs nothing to talk to us. At least we can tell you, first of all, what we think the insurance company is going to do, and number two, if it's going to go negative, if they're going to deny you again, at least you'll know what your options are. And that's going to, I think, diminish some of that stress that people have, because they're very stressed about, well, am I going to get approved? Am I not going to get approved? Well, now you'll know what to do if you don't get approved. And that is something big, John. I mean, people, when we talk to them, that's the biggest thing I get out of this, is that people feel relieved that they have this information and they know where to go if things go south. We are here for them. We are here for you. We will help.
Well, it's interesting, too, because an appeal may turn into appeals and more wasted time. It's not just one. You can do it more than once if you'd like.
Most people do. Right. Most people, in fact, try at least 2 appeals. And generally, when I see people coming to us after they've gone the appeal route, they've wasted about 1 year to 1.5 years of time. Sometimes, and it's more rare, but sometimes they've gone through 3 or 4 appeals. And sometimes they even go beyond that 2-year limitation period. And that's key to understand. If you've been denied long-term disability and you start doing these appeals, and you get to a point where you are now over 2 years past that date of forced denial, the insurance company is most likely going to take the position that you are out of time to go the legal route, to actually try and force them legally to pay you what you're owed, in which case they're not going to pay you anything. And John, that is a difficult thing. There's some mixed case law as to whether or not that 2-year limitation period, the clock starts running from the date of first denial. We take the position that it's better safe than sorry. Do not let that 2-year expiry or that 2-year period expire. You should be contacting us as soon as you can, but certainly not beyond the 2 years after you were first denied, because at that point, your legal claim may be in jeopardy.
I think it's interesting, too, that you mentioned that people just want to be compliant. They don't want to ruffle feathers with the insurance company. And they hear this word appeal. It's got this whole, legal thing, too, which it sounds like it's going to a government agency and it's going to be appealed in front of court and judges and gavels and all that stuff. It's internal, isn't it? It's
completely internal.
Right.
It's the exact same people making the decision.
Right.
Maybe it's Sue and not Ruth, in the next cubicle that's making the decision. Maybe it's a committee made up of some people who really don't care about you. That's the reality. Listen, insurance is a business. It's a billion-dollar business. I don't begrudge them. I understand they have to make money. The law allows them to do so. What I hate about this whole thing is that it's the only product that I'm aware of where you are paying for that product only to have a headache down the road when you try to get what you've paid for,
right,
or what your employer has paid for if it's a part of health group benefits. So you need to understand that the insurance company is not your friend. When you have a policy of insurance, LTD, house insurance, car insurance, whatever it is, what you have is a contract that obligates the insurance company to pay you if something happens. And yes, there are certain criteria, and the insurance company is very good at throwing that criteria at you and telling you you have not fulfilled that criteria. But oftentimes, their excuses are hollow. One of the common ones, John, I know we have to move on, but I got to say this. One of the common ones is they say you're not totally disabled.
Oh,
we've talked about that before, and I'm sure it's going to come up again. And they just throw that term at you. And when you're told, I'm not totally disabled, well, yeah, I'm not totally disabled. I'm not paralyzed. I'm not brain dead. But that's not what that means in the context of long-term disability law. So you see, they're not there to help you out. They are there to try and convince you that you have no case. So don't be compliant. Be compliant with not being compliant. Ask them questions. Question them. Come to us. Come to our website. Do your own research. I mean, the reason I tell people to come to us is because as opposed to Googling this stuff, we can give you the answers for free.
Right.
That website you mentioned, LTD FAQ, that's a website that we created, ltdfaq.ca, because people are asking us the exact same questions about very, very similar topics. And so we've created this website to empower people. It's a free website. It's free memos. It's written in regular language, regular English.
Yeah.
So go there, check it out. Give us a call if you have any questions.
Another resource you can use anytime is called pocketemploymentlawyer.ca. You think, okay, that's employment. That's your other show with Lior. Yeah, but there's a lot of crossover, as you mentioned, right, with that.
Tons of crossover.
We have the website.
Yeah, tons of crossover. I mean, listen, we have employment lawyers, we have LTD lawyers. Those two areas intersect many times. Mm-hmm. People have issues with their workplace. At the same time, they've applied for long-term disability. They've been denied. The employer says you have to come back or we're going to fire you.
Yeah.
People don't know what to do. And so you go to Pocket Employment Lawyer to get answers, customized answers about your employment issues. At the same time, you want to get information about your LTD. You go to that website. It's free. It's anonymous. It's quick. It's customized. If at the end of that, if you get your answers and you still want to speak with us, no problem. Click a button. We'll contact you. You don't, close the browser. We will not know that you were there.
Yep. DisabilityRights.ca, that's the firm website. You can go there. Sivan mentioned a few minutes ago, we're on radio across the country, helping people across the country outside of Quebec, so feel free to reach out and go to the website anytime. And find a radio station in your market that you can listen to our hour-long show on a weekly basis. Sometimes we get some great phone calls coming through as well, and we talk about them here. Our first phone call for the day is coming up right now.
So I have a good friend, and he started the chemotherapy treatment. Now from the company, he was trying to work, but he couldn't handle it. So they are giving him a short-term disability with EI, and after that, he doesn't know what to do. And this treatment has to go about 2 years.
Great call. What do you think?
Yeah, so this is a big issue, obviously. People who are diagnosed with an illness, whether it's cancer or other things, MS or other types of illnesses, unfortunately, that prevent you from working. Look, you will have short-term disability either through work or through EI, sick benefits, or whatever your provincial legislation is that allow you to be off for a period of time for sickness. Many employers carry health benefits extended health benefits that also give you access to long-term disability. You can't apply for long-term disability in the context of insurance. I'm talking about insurance companies, not governmental, unless you have coverage for it. So either you have it through work or you have it as part of extended health benefits, either through work or privately, or you purchase it privately. Exactly. So what's important here with this gentleman here is that his friend is obviously on the short-term disability while he's undergoing chemotherapy. Once that is over, once that is done, or actually before it's done, he should be applying for long-term disability. Now, John, believe it or not, I have seen cases where people who have been going through chemotherapy, people who are, clearly unable to work, where you have oncologists who are writing a report to the insurance company saying this person cannot work, and insurance companies still ignore it and still say the person is not disabled enough, or we think that they can do some kind of work with accommodation from the employer, so it's an employment issue. If your friend here applies for long-term disability and gets denied, we will be able to help so long as the oncologist, the family doctor, whoever he's seeing says that in fact he is disabled from working. Now, if he doesn't have long-term disability access, there are governmental programs out there that may be able to support him financially. And again, ltdfaq.ca, that website, it contains a memo about governmental financial assistance programs, specifically in Ontario, BC, and Alberta. Although every province has some kind of legislation that deals with this. So that's what they need to understand, John, is that oftentimes somebody is on short-term disability either through government assistance or through, let's say, a work program that pays you STD, short-term disability, and then they try to apply for long-term disability, and they should be approved in a case like this, but obviously if the person is denied, we can help them.
Coming up after a short break, the difference between a denial and a cutoff of LTD benefits. In the meantime, reach out. Get this number down, 1-855-821-5900, and help at disabilityrights.ca. We'll continue with more of the Disability Law Show. Stand by.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back, Disability Law Show. Thank you so much for joining us this half hour. You want to reach out beyond this, you can make a phone call, 1-855-821-5900. Email is help@disabilityrights.ca or simply disabilityrights.ca, the firm website. There's links there to our media of other sources, like radio shows across the country as well. Always willing to help across the country. If you're outside of Quebec, you're good to do so. Make that phone call. Topic for the day, Sivan, the difference between a denial of LTD and a cutoff of benefits when it comes to LTD, what you should do next. Number one, what is the difference between an LTD denial and being cut off LTD?
So that's a good question because some people don't know, they haven't been through the process. It's very simple. LTD denial is when you've applied for long-term disability and you've been denied. The insurance company says, you're not getting a cent from us. We're not going to pay you. In contrast, a cutoff is when the insurance company has approved your long-term disability claim and they've been paying you for a period of time, and then at some point, for whatever reason, they've decided to stop paying you. Maybe they've paid you for a month, maybe a year, maybe 10 years, but at some point they're cutting you off. So that's the difference. Now, how you deal with them, we're going to get into that. That's a bit different, but the point is that the difference is that one is a denial at the outset and the other one is a denial after they've paid you a certain sum of money already.
So one, you haven't even got your foot in the door yet. You
Yes.
haven't got a red cent. And then the other one is you've been getting paid. Now they're going to turn the tap off.
Exactly.
Now, number two is this. Can your doctor help if you've been either denied or cut off LTD?
Yes, absolutely. In fact, your doctor is going to be crucial every step of the way. once you are disabled from working, you want your doctors to continue being on your side. And I mean, you don't want to strong-arm them, obviously. You need their support. And if your doctors are supporting you being off work as a result of your disability, be it physical disability or psychological or a mix of two, your doctors are going to be instrumental here because you're going to need them to continue providing updates at regular intervals to the insurance company. If you've been denied LTD, presumably you've been denied because the insurance company doesn't deem you to either be disabled or there is some kind of a technical reason why they denied you. Either way, you could only have received LTD if you had medical support supporting you being off work. So your doctor had to have been on your side.
Gotcha.
That's number one. Number two, for cutoff of LTD, oftentimes people get cut off LTD at that 2-year mark that we're going to talk about a bit later. That 2-year mark when the change of definition happens. When now to get LTD, you no longer have to show and prove that you cannot do the essential tasks of your own occupation, but of any occupation for which you're suited for. Again, a doctor or whoever's treating you, their reports, their opinions are going to be very, very important to challenging the insurance company's cutoff decision, to go after the insurance company, to allow us to knock on the insurance company's door and say, you are wrong and you're going to have to pay this person. But to do that, we need your doctor's help because we need their support saying that you are in fact unable to work.
So whether it's a denial or you're cut off, at what point do you reach out to you, a disability lawyer, and get the ball rolling?
Fantastic question, because there is a misconception, I think, on the latter, on the cutoff. So let's deal with the first one, which is simple. If you're denied long-term disability, it's really simple. You should be contact us immediately as soon as you get the denial. So the day you get the letter or the email saying you are not approved for LTD, your next phone call or email is to us, because we'll be able to assess whether or not that's legitimate, whether the insurance company is correct or not. And it's on the phone. We can tell you on the phone. We'll review the denial letter. If you have a copy of your policy, that's fantastic. If you have any medical documentation supporting your disability, we'll want to see that. If you're unionized, we'll probably want to see the collective agreement if you have a link to it. But the point is, we can give you advice immediately on the denial. So immediately when you get denied, you should be calling or contacting us in any which way.
And you'll stop the appeal if they're about to do that.
And stop the appeal. Don't appeal. Yeah. That's not what you're doing. You're calling. Even if you want to do the appeal, talk to us first.
Right.
So maybe you'll get some nuggets of information that we can give you to strengthen your appeal if you are intent on doing so. A cutoff is different. Here's what happens typically with a cutoff, and this is important to understand. Typically, insurance companies don't cut you off retroactively. They don't say, hey, John, by the way, remember that check you got 30 days ago? You're not getting another one tomorrow. They don't typically do that. I've seen that happen, but that's rare. Typically, what they say is, either we've conducted surveillance or we sent you to a doctor of our choosing and that doctor has said that you're ready to go back to work, or they give you some kind of a reason for why your benefits will be cut off. But they tell you that they will be cut off in the future.
They give you a heads up.
A heads up.
Yep.
Maybe it's 2 weeks from now, maybe it's a month. I've seen it as far as 12 months in advance. Now, leaving aside the fact that that's kind of strange, how can you know in 12 months if the person is ready to go back to work?
Ball it.
You got it. But the point is, you are given a heads up. Here's what most people do. This is the trap they fall into. They fall into the trap of thinking, well, I have 3 months or 4 months or a month before my payments stop, so I might as well appeal, or I might as well try and have that, nice conversation with this adjuster who I think is my friend. Maybe I can convince them not to cut me off. Wrong. They will cut you off. Once they say that they're cutting you off, it's in their system.
Right.
The train is going to get on, it's going to get to that point, right, the end of the tracks, and it's going to fall off. What I suggest you do, and this is critical because it's happened with a few people who've contacted me who were told that we're going to be cut off in a few months' time, is we started the process of going after the insurance company immediately at that time. When they've come to me and said, look, here's a letter saying I'm going to be cut off in 3 months, and I've looked at the letter and I've looked at the medical documents and I've looked at everything, and I said, no, they should not be cutting you off. We started a claim against the insurance company. And in some instances, actually quite a few, we've been able to resolve the claim with the insurance company to rectify the situation before there was a gap of no money coming into this person. But if people fall into the trap of thinking they can avert this on their own, or they can appeal and somehow they have time to appeal, you know what happens, John? The time comes, the deadline arrives, the payments stop, and people are without money. Then they panic. Then they call the insurance company incessantly. At some point, they get a letter from the insurance company saying your appeal has been denied. Now they really don't know what to do. Now they're really
reach
panicking.
out to you, finally.
They reach out to me half a year later or a year, and I tell them, had you reached out at the beginning, we would have resolved this right now already for you. So don't wait. So that's the difference. Cutoffs are a bit tricky because people think they have time. There is an old proverb that says, you got to do things now because it's later than you think.
So true. We'll take a short break, get into an email when we come back. help@disabilityrights.ca is how you send one along anytime. And the phone number, 1-855-821-5900. Lots more to go. It's a Disability Law Show. Stay with us.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Thank you so much for hanging around. Disability Law Show, reaching out beyond this point of the show. You can do so 1-855-821-5900, disabilityrights.ca. That's the firm website, and then help@disabilityrights.ca. Anytime to send along an email. It may appear on a future show or one of our radio shows as well. Isaac writes in, Sivan says, continuous headaches and blurry vision led to an eventual diagnosis of a hematoma in my brain. I still have migraines and become dizzy when I look at a screen too long, and my job requires me to work at a computer all day. My neurologist says I should stay off work until I see the neurosurgeon. I was denied LTD, however, as I still do some of the daily personal activities. Should I appeal this decision?
So the answer is no, Isaac. I think we've spoke about this quite a lot. Definitely do not appeal. But John, this is one of those cases where when you have a neurologist, when you have people of that level, on
beyond
the medical
a GP,
side,
a specialist, right?
Yeah, and nothing wrong with GPs.
Sure,
Some
absolutely.
GPs are phenomenal, but yes, exactly that. When you have people who are at that level and we're dealing with very sophisticated testing and the symptoms here, I mean, who can work with continuous headaches, blurry vision, hematoma in the brain? I mean, that's crazy. He becomes dizzy if he looks at a screen too long. I mean, look, if his doctors are saying that he cannot work, I would love to understand what was going through the mind of the adjuster that denied Isaac's claim. Because I can tell you right now that there is no question that he would be entitled to LTD. Yeah. Now he's asking, should he appeal? Okay, we answer that. However, let me deal with something else here. The insurance company says that he can still do some personal activities. You know what this sounds like to me, even though we don't have the reason for denial? It sounds like to me like the usual baloney excuse insurance companies use to deny claims where they say you are not totally disabled. Yeah. So let's unpack that for a second. Total disability, what does that mean, right? Insurance companies say in order to qualify for long-term disability, you must be totally disabled. And so when you read the word totally, or when you hear the word totally, you're thinking it means everything, 100%, the whole thing.
Yeah.
I've totaled my car. The car is wrecked completely. And you're thinking total disability means you are, in fact, paralyzed. You cannot do anything. You are in bed all day. That's not what it means. It's just not. And to give the most extreme example that we've used before, you can have a surgeon who's hurt his or her pinky finger, and now that surgeon can't work, can't do the surgery. Maybe they can do other things, but not surgery. That person would be considered disabled under an LTD policy because that person cannot perform the essential tasks of his or her occupation.
Right.
Same thing with a concert violinist. Yep. Now, again, this is an extreme example. My point is that it doesn't matter that you can do personal activities. It doesn't matter that you can go pick up your kids at school. If ultimately whatever is disabling you, which, by the way, we can have the same symptom, but we may be disabled in different ways. Right. Maybe, John, you can do the essential tasks of your employment. Maybe I can't do mine, or vice versa, because of a similar injury or illness. The point is, it's very specific to the individual. It's very fact-based. So, for Isaac here, we don't know what he does for a living, but ultimately, it doesn't matter if he can do any personal activities. If because of the symptoms he has, the constellation of symptoms he has, his doctors feel that he cannot perform the essential tasks of his occupation, he should qualify for LTD, period, full stop. And this is one of those cases where I can tell you, I've had cases similar to this, again, without having all the facts, just looking at the generality here, where I have written to the insurance company and they've reversed position just because of my letter. In other words, they understood that if we went to court for this, they would lose. They would lose after paying their lawyers God knows how much money. So, Isaac, we can help you here, no question.
Let's get to one from mydisabilityquestions.com, another free and anonymous website you can ask your questions. Again, maybe showing up on a show. Got time for Joanne. Says, after a failed return to work from disability, my benefits resumed through a recurrence claim, but only up until the 2-year mark. My doctors have indicated that I have a long road to recovery. What happens if I'm still not well enough to return after that 2-year mark?
Let's unpack this. Joanne, I understand exactly what it is that you're asking here. So what our viewers need to understand, John, is that under most LTD policies, there is a safety net built in, a mechanism in there that allows you to try to go back to work, but also be able to get back your LTD without waiting the initial elimination period. So when you apply for LTD, there is a period of time where you must be disabled throughout it, 90 days, 120 days, whatever that period of time is. And once you're past that period of time, you start getting LTD. Usually that corresponds with shortened disability payments. Okay, right. Not always, but usually.
Sure.
And so what happens in a situation where someone like Joanne tries to go back to work, either because she wants to or because she's been pressured into it by the insurance company, if she tries to go back to work and she's successful, the insurance company doesn't have to pay her anymore because she's back to work, she's getting income. But what happens if she finds out that it's premature and she can't go back to work? Well, at that point, the recurrence provision should be triggered, which means she goes back on LTD immediately. So she doesn't have to wait. She doesn't have to wait that 90 days or 120 days or however long that period is. Now, in this case, she's saying that she only received LTD up to the 2-year mark. Again, the 2-year mark, right? It's the common theme that we hear. Insurance companies cut people off at the 2-year mark. Why? Because insurance companies tend to say, sometimes with no evidentiary basis, that you are able to work in some other profession. You can do something else that will pay you a certain amount of money that is commensurate with, let's say, 65% of your pre-disability income. And so insurance companies often cut people off at that time. So in this case, we have that complexity here, right? On the one hand, there was a recurrence clause. It was triggered because she wasn't able to, in fact, work for the entire duration or go back to work as needed. And so she went back on LTD, but only up to the 2-year mark. And her doctors are saying she's going to be off work or she should be off work for a long period of time. To me, this is a very strong case. Why is it a strong case? Because she tried to go back to work and she failed.
Yeah, trying to mitigate.
Yeah, and her doctors are saying you should be off work. So this insurance company or this adjuster is crazy. And the reality is that we can hit back very fast. John, I want to say something else to our viewers. Many people, when they contact us, think, we watch American TV, and so we think that these cases always go before a judge. We think it may take years and years and years. Long-term disability claims generally don't take that long to resolve. It all depends, obviously. Sure. Sometimes we resolve them in a few weeks. Sometimes it does take us a year. Typically speaking, we resolve them in a few months to a year, depending on the complexity of the case.
Sure.
But the reality is, in a case like this with Joanne, when she's tried to go back to work, she's failed, and the insurance company cut her off anyways, very strong claim. I can tell you we can help her.
And some people, I know we're just about out of time, some people think that their policy only lasts for 2 years.
Yes.
That's another mistake they got to phone you about.
Misconception, right? Absolutely. Give me a call if that's what you're thinking.
You got it. Phone number as we wrap it up here, 1-855-821-5900. Email is help@disabilityrights.ca. And we did mention as well, LTDFAQ.ca, a very simple and easy to use, concise website. Building blocks of LTD facts. You can use them, digest them. It's not in legal speak, real simple to use, ltdfaq.ca. And then again, help@disabilityrights.ca. Love that email address. And hopefully we'll catch you on one of our radio shows in the future as well. Thank you so much for joining us once again, another edition of the Disability Law Show. Take care.